We live under a growing number of bad laws. Laws that were never directly approved by the public, yet impact us all. These laws didn't write themselves. Legislators did. If they are the source of the problem, we cannot rely on them to be the solution. That's why we propose a People's Parliament. A citizen-led body that crowdsources the identification of harmful legislation and proposes repeals, amendments, or replacements to restore sound governance. If you're frustrated by a bad law and just can't seem to change it through the system, don't take the law into your own hands. You bring it to Parliament, the People's Parliament.
Hello, everyone, and welcome to this second episode of the People's Parliament. I call this commission into order, I guess. Today, I will be acting in my capacity as both the moderator and the organizer. I'm joined by my fellow commissioners, Mr. Doug Bebb and Mr. Glenn Volushka, as well as the subject matter expert, Mr. Trevor Holsworth. As moderator, I'm going to begin this proceeding by going over the rules. This commission will run for a maximum of 3 hours. The guest is again reminded that it's a structured interview, and you may be, from time to time, interrupted purely for the purposes of keeping this commission on track. To keep things professional, we ask that no profanity be used and no inappropriate behavior be displayed. If any commissioner has a question at any time, they can raise their hand, and I, the organizer, will call on them. We ask that statements be in the form of questions to the subject matter expert and not merely statements. Furthermore, we ask that you keep your questions as brief as possible. The spirit of this commission is to identify the laws which are impacting our lives. We ask the commissioners, organizer, and the subject matter expert to not focus on social issues, for example, cultural Marxism, which is not of concern here. And I will now hand this over to myself in the capacity as an organizer. The subject of today's commission will be the Judges Act, which is an act which governs how judges hold themselves to account. Mr. Holsworth, I believe you have some comments prepared before we begin with the commission. Go ahead, sir.
Sure. Thanks, Payman, and congratulations, and thanks to the commissioners as well for volunteering your time and coming on the show. It's much appreciated to bring light to how we are governed. I wanted to sort of emphasize that the Judges Act is one of the core governing documents behind. We've got the Charter of Rights, and that's the Constitution, and that is our overall structure of how our government works. And then we have acts of Parliament, like the Judges Act, which further clarify what the Constitution says. And the Judges Act regulates how the judges are disciplined and how that discipline process goes and how they are appointed and paid and those kind of things. So it's a really important document as far as how the actual people of Canada are governed, which is what judges do, is they do the criminal law and the civil law and allow people to access justice. And that's what we're concerned about here.
All right. Thank you very much. I guess we can start with the commission. And again, I ask the audience to bear with me as I will be acting as a moderator as well this time. So let's start out with Section 3, Mr. Holsworth. I'm going to read this. Section 3, no person is eligible to be appointed a judge of a superior court in any province unless that person is a barrister or advocate of at least 10 years standing at the bar of any province. For the audience who might not, they're not as well versed in this as you are, the bar in this context, this would be like the BC Law Society in British Columbia. Is that correct?
Yeah, exactly. So the judges are pulled from the ranks of lawyers because they're trained. It's a system which is sort of internally coherent, and judges become experienced lawyers become judges. The problem that provides, or it means that the only people that are in that system are people that are in the system, and everyone else is excluded. So the system, So the problem is also linked to the BC Law Society, in that if you control the BC Law Society or the law societies of any province, you control who gets to be a judge. So that's where the current debate in the BC Law Society over who controls the BC Law Society, and right now the Attorney Generals of the government are trying to attempt to take over the BC Law Society, means that they can remove lawyers that they don't like, which then means that they are removed from being ever judges. And of course, the public is never able to be a judge. And that's the way the system is structured.
That's excellent. You preempted my follow-up question. Do you think that, does this pose a conflict? For me looking from the outside in, I'm very critical of the justice system, and I think this is a conflict. I want your opinion, and if any of the commissioners disagree with me, I welcome your opinion as well.
Well, what it ends up doing, particularly in the Judges Act, is that it means that judges are always judging judicial conduct, and the public or no other body really gets a shot at judging judicial conduct, because it's all internally regulated.
Mr. Bebb, go ahead. You're muted, Mr. Bebb.
Sorry about that. I just have a quick question, if it's possible for you to compare that system with what I believe exists in the U.S., where there's elected judges. Does that provide some input from the public that doesn't exist in this country?
It does. It provides democratic legitimacy to that process, which does not exist in the Canadian system at all. There are criticisms of the U.S. system, but it is a system of democratic accountability.
Thank you, Mr. Holsworth. If there's no more questions, moving on. Another question I had, sorry, I just realized maybe if I can make it a little bit larger for you guys. Section 3, subsection B, no person is eligible to be appointed judge of Superior Court in any province unless that person undertakes to participate in continuing education on matters related to sexual assault law and social context, which includes systemic racism and systemic discrimination. Can you speak, what is the significance of this? Is this good legislation, or is this politics creeping into our justice system?
That is the debate. That is
Mr. Holsworth, you're muted.
For sure. And it is a little bit of politics moving in, but it's also controlled by the judges. So there's a balance in there. Yes, we should have education for judges, but who controls the education and how it fits into creating equality before the law and all those kind of things is a challenge. But basically, if you've got one group having a connection to the judges or an ear to the judges and another group not, then do you have equality? That's kind of the problem.
Mr. Walushka, go ahead, sir.
Do you see this as a blatant form of social engineering? I guess my problem when I see them specifically dealing with an issue, that relates to presumably sexual potential orientation, sexual conduct, that's one form of social engineering, but I see so many other areas that are potentials for corruption. And why would you see them not being specifically addressed? Do they believe that the Bar Association and their vetting process has dealt with those issues? I mean, I'm just curious to know why this seems to be a specific target in the legislation.
Yeah, you're totally on the ball, Glenn. Those amendments were brought in 2021 when the DEI whole movement was really gaining power in the federal government, and so they are responses to that, and there's sort of a DEI connection right across the entire government structure, including the judiciary. And you're correct in that there is absolutely zero checks and balances on the judges as far as corrupt activities. It's all on whether or not there was, how they were doing on sexual misconduct or whatever, but nothing on actual corrupt activities. And that's by design, would be my put. They kind of claim that I think we'll get to it later, but the whole judicial misconduct area of the Judges Act is completely bypassed because they assert that they cannot judge the exercise of judicial discretion, including the weighing of evidence and the weighing of the law, so that judges then have complete discretion to do anything they want with evidence, which of course opens it up to all sorts of manipulations.
Next up, I want to go over section 59.4. I'm going to read this one. Each member of the council may appoint a judge of that member's court to be a substitute member of the council, and the substitute member shall act as a member of the council during any period in which he or she is appointed to act. But the Chief Justice of Canada may, in lieu of appointing a member of the Supreme Court of Canada, appoint any former member of that court to be a substitute member of the council. Is this just how law is written? Or to me, it seems like this is absolutely broad. It's giving them full discretion to do anything.
Yeah, they just give themselves complete discretion to operate things in as much as they want and to chop and change things as much as they want. And I don't think there's anything necessarily untoward, indirect in this thing, but they're basically saying we can move people around and we can step out and someone else can step in at any time. And it just makes it fairly open.
Do you think, is this the way it should be set up? So is there an argument to be made that the judges know how to manage themselves and police themselves best, or should there be like a civilian oversight?
Right. Well, that is the crux of the issue. The kind of unwritten constitutional principle is that no one, the principle of fundamental justice is that no one can be a judge in their own cause. And yet judges claim they can only be legitimately judged by themselves. But that's not really the way that the law is written. The actual law is that the people are the ultimate judges of judicial conduct. So when the Judges Act was going through Parliament, I submitted a brief with an amendment or a proposed amendment to the Judges Act, which placed the jury of citizens on top as judging judicial conduct. And all the referrals will go through a jury of citizens, which would be a rotating pool of citizens, not to sort of create a system where you have people that are captured doing the job, but a true jury. And there was absolutely no comment on my submission at all. It was completely ignored. But that's the legitimate constitutional interpretation, is that the citizens should judge judicial conduct, but the judges absolutely don't want that.
If there's no questions, we'll move on. Thank you, Mr. Holsworth. Next, we're moving on to section 60. The objects of the council are to promote efficiency and uniformity and to improve the quality of judicial service in superior courts. My question is, do you agree with this? Is there anything that you would add or remove?
Oh, do you want to let
Mr.
Glenn have
Belushka?
a
Yes.
conversation there?
Go ahead, sir.
I apologize. I'm probably remiss in not asking this on the previous screen in the previous section that we were addressing. I guess one of my concerns would be whether there is a reason that you would have this substitution by way of some judges either of necessity or of their own volition recusing themselves in certain cases. Is there a recusal mechanism that exists that appears satisfactory, and is that substitution of judges potentially there as a result of a recusive necessity in your mind?
That's sort of separate from the Judges Act. Specifically, it's more of a function of judges in their capacity as judges, in that they reserve, they have an obligation to recuse themselves if they have a conflict of interest, and someone else would step in, and it's sort of a safety protocol, but it's voluntarily sort of monitored with very little ability to check it. I guess you can appeal their decision, but you're appealing to another judge to make that decision once again. And so you're kind of limited to judges deciding whether or not they're doing their job correctly.
Yeah, I was just wondering whether the substitution clause here relates to somebody that's maybe not potentially able to participate because they're incapacitated, busy elsewhere, or whether there is some recusal possibility even at this level of dealing with the Judicial Act, right?
Right. Oh, I see what you're saying. I don't think there is anything in the Judges Act that brings up the idea that they could recuse themselves for conflict of interest in the Judicial Council itself. I don't believe that's in there, but I'm sure that's within their discretion as well to say, look, I'm compromised here. And that allegation was sort of made with the Chief Justice with COVID in his declarations during the COVID issues. And a complaint was made about that.
Thank you, Mr. Belushka. I guess just very quickly, I'll read it again. Section 60. The objects of the council are to promote efficiency and uniformity and to improve the quality of judicial service in superior courts. I just want your opinion. Do you think this is sufficient? It's valid? Anything you'd add or remove?
It certainly lays out what the purpose of the Judges Act and the creation of the council are for, and it does so succinctly and addresses the major issues. Improve the quality of judicial service. That's great idea. And efficiency and uniformity. Is that we should all be equal before the law, and we should all have an efficient legal system.
Just going to give it a moment. I think we had some technical issues.
Sorry, I think that was me probably. So I think generally it's a reasonable set of things to put out there. I don't think there's anything necessarily wrong with anything there.
All right, thank you. Next, we're gonna focus still on section 60, but I want to go to the powers of the council, subsection 2, subsection 2B. Powers of the council: establish seminars for the continuing education of judges, including seminars on matters related to sexual assault law, intimate partner violence, coercive control, and intimate partner and family relationships and social contexts, which includes systemic racism and systemic discrimination. Now, we're going to come up against this a couple of times in the body of the other parts of this legislation. I'm not diminishing the traumatic effect of sexual assault, but my question is this politics creeping in, because it appears everywhere, and every time they mention sexual assault, there's also systemic racism and discrimination.
Yeah. So the fact that they are labeling what the seminars are about indicates sort of the power that DEI has had in creating this federal legislation. They could have said that the judges have a responsibility to continuing education on all sorts of manner of things, but they didn't. They chose to talk about this issue, and that shows political influence on a particular side of the issue, and it's not a balanced side. And that's the problem with that interpretation, I think.
Mr. Bebb, go ahead.
Unmute. Yes, thanks, Payman. There's probably a distinction to be made here between form and content. And form, I think, is in the proper, purview of this act. But content, such as this, elevation of DEI, and probably also in the government's attempt to control the Bar Association to affect the content and structure and makeup of the council, really does seem to blur the line of separation of powers. Is that a reasonable estimation of what's going on here? Trevor, you're muted.
Yeah, I'm thinking about that, Doug, but it's a good question. Separation of powers. Yeah, I think it's just a concern in that who has influence over the judges, and who is communicating with the judges, and what are they saying, and how is it being said, and these are all things that the public should have sort of an interest in, and an involvement and understanding of what is being taught to judges, and how that's being portrayed. I'm not sure exactly what you mean by the separation of powers in this context. Maybe you can expand on that.
Glenn, you want to take that?
Yeah, my concern, I guess, is trying to establish in my mind, and maybe in the minds of many people who might be, listening in or reviewing this after the fact, is trying to determine why there would be a necessity to put this into this particular act when we have things like human rights commissions that I understood were supposed to be put in place to deal with things like systemic racism and systemic discrimination. I'm really puzzled, other than for political purposes, why there would be any specific mention of these kinds of issues when it comes to training people for this particular function of the judiciary. Have you got a comment on that maybe clarifies that for me?
Yeah, I think you're hitting the nail on the head there. Is that there is a political direction being directed at the judges that they must consider this particular aspect from this particular perspective, and it's very much directed and controlled by the DEI system that's being brought into the public service of Canada. And so essentially you have the DEI network controlling or having a significant voice in judicial education. Go ahead.
Now, just as a follow-up to that, if there were decisions rendered by human rights commissions in various provinces, is it possible that their decisions would be appealed up to this particular body, or are they somewhat independent?
Well, I mean, the judiciary or the courts are above the tribunals. The tribunals are strictly basically an executive function. They're all appointees performing executive roles, whereas the judiciary or the court system is supposedly completely separate from government. So to see this creeping in is an infringement of executive powers over judicial powers, and I think that's a very valid comment.
I guess my concern is it almost like a double dipping situation? I mean, if the Human Rights Commission renders a judgment, could you just hypothetically, as a citizen who was impacted by that Human Rights Commission judgment, then appeal up to this body? So, in fact, you're dealing with the same kind of filtration effect or the same kind of broad brush effect when it comes to systemic considerations, or is this does the Human Rights Commission have accountability, I guess, to this particular judiciary body that we're discussing today?
Right, not directly. You can't complain about the conduct of a member of a tribunal to the Judicial Council. They are only governed by, they only govern the Superior Court judges. So anyone in a Supreme Court or any one of the higher courts, not the provincial courts, not the lower court of the provinces, but the federal judges are all in BC, it's the Supreme Court of BC or the BC Court of Appeal, and also the Supreme Court of Canada and the federal courts. They're all governed by the Canadian Judicial Council. So, I mean, if you were in a tribunal and you appealed from the tribunals to the Supreme Court of British Columbia, for instance, which would be the natural way you would do it, and then you had, at some point in time, you had a complaint about the judge of that court, then it would be under the Judicial Council, but not beforehand.
I actually have a follow-up question based on Mr. Volushka's question. How would you explain to a child the difference between the tribunals and a court, given that our courts are also technically under the executive? Like in that we don't have co-equal branches like the US does, unless I misunderstand that.
Well, you know, you're hitting a very interesting part, is the judges assert that they are independent from the executive, even though they're appointed and can be dismissed by the executive with approval by Parliament. But the tribunals are completely controlled by the executive. The judges or the quasi-judges of those tribunals are executive hires, and they are fired whenever they want to. So there's not the same control over judicial independence that they talk about with federal judges. Does that kind of answer your question there, Payman?
Yes, thank you. No follow-up questions. Moving on. Next is section 62. The council may engage the services of any persons that it considers necessary for carrying out its objects and duties. Simple question, but it seems reckless to me. I mean, you're giving absolute authority to the council.
Yeah, you know, and it's kind of legitimate in some ways. Is like, you know, okay, you need to be able to employ people to do the job of the council, and you know that should flow from that, and it, you know, there's sort of a legitimacy to that. But that, I think that was also how they kind of came up with this idea that they could employ someone to look at all the decisions or all the complaints coming and then weed out some complaints that they didn't want to hear and then only submit certain complaints to the actual council. So I think they used that, saying, well, they've given us the right to hire people to do jobs, but you cannot delegate a core authority you can't subdelegate a core authority of the act. So the core authority of the act was to judge judicial conduct, but they subdelegated that down to like a junior lawyer to judge judicial conduct, and you can't do that. It's an illegal subdelegation of a statutory authority, and that's what they were getting into trouble with. I think I lost a little bit there. I'm not sure if you got all that. Oh, you're frozen. Sorry. I think I missed a bit there. Did you catch anything that I said, or?
We caught the first part of it. Just a bit of
Maybe
at the
just
end.
ask the question again.
It's okay. I think your response to me was it is in certain cases necessary. So it's not
Well,
like
yes. So that was I think that was the process they used to say, oh, we need to hire a screening officer to look at all the complaints before they get to the Judicial Council, who are going to examine judicial conduct. And so they hired a screening officer, which was not authorized in the Judges Act, because the judging of judicial conduct was said to be only something that judges could do. But then they subdelegated it down to a non-judge, which is improper, and that's why they made the amendment to the 2023. Was they specifically wanted to create a new section saying that they have authority to create a screening officer.
understood, Mr. Bed.
Go ahead, Doug.
Yeah, I just got a quick question. Do you have any idea of the volume of complaints that are received? Was that some sort of a necessary function to reduce workload, or is it simply a dodge?
Yeah, so back in the 80s, I think there was about 200 complaints a year that came through, and we're hitting into the 1,000, above 1,000 per year, and that's just the ones that they officially recognize. There's a lot of problems with transparency with the Judicial Council. It's actually not. It's one of the only bodies in Canada's regulatory system that is not controlled by the Freedom of Information Act. You cannot get information out of the Canadian Judicial Council. Go ahead.
Good.
So I presume that these complaints, whether they're accepted by the screener or not, are not made public. There's no publication of them. That would be a good place to start.
Yeah.
Whether or not they're vexatious or founded, it would still be good to see.
Yeah, there's absolutely no accountability and no decisions made public, basically, unless the Judicial Council makes it public. And there's no publication. It's a complete failure of accountability and open court principles at the apex of the system.
No more questions. Moving on. The next one is 62.1. This is another one creeping DEI. We might be beating a dead horse at this point. Within 60 days after the end of each calendar year, the Council should submit to the Minister a report on matters related to sexual assault law, intimate partner violence, coercive control in intimate partner and family relationships, and social context, which includes systemic racism and systemic discrimination. I mean, I don't know if you want to comment on this, or if we've already commented, we can move on.
Yeah, I think we've covered the problems with that whole system and why it's been implemented, and you can see the power that it was created in the statute, and it was basically the only thing that they debated in the Senate, and they had my complaint before them, and the only thing that was ever brought up by the senators was basically sexual assault and that kind of thing. And whether it was DEI, and whether or not it went through their gender-based analysis process was the concern. And so political.
Any questions? So the next section is 73. I'm going to read this. This is regarding an office or a position called the Commissioner for Federal Judicial Affairs. There shall be an officer called the Commissioner for Federal Judicial Affairs, who shall be appointed by the Governor in Council. This bill gets really convoluted. I've noticed this with all bills, actually, or party constitutions. They create all these random bodies, positions. Is this the main adjudicator of complaints, or is this something else? Do you know, Mr. Holsworth?
Yeah, so I don't know a lot about the Federal Judicial Affairs Commissioner, except for the fact that his name is Mark Giroux, and he is also has a position at the Canadian Judicial Council. And so he oversees complaints. So you have the same person controlling multiple bodies, and they all have conflicts of interest with that role. But you're basically limiting the number of people that are involved in the ultimate system. And that's sort of, I mean, the federal, I'm not exactly sure what the whole mandate of the Federal Affairs Commissioner there is, but I do know that role is shared by one man.
Another question. I made this mistake last time. Mr. Bebb corrected me. The Governor in Council, is that the Governor General, or is that something different?
Yeah, so the Governor in Council is basically the Governor General as advised by Cabinet. So the Governor in Council is comprised of all the members of Cabinet plus the Governor General. And the Governor General basically decides based on what they're told by the Prime Minister or the Minister of Justice and Cabinet.
Go ahead, Mr. Volushka.
Just for the benefit again of the viewers, are we talking about what is also known as the Privy Council in some circumstances?
I think the Privy Council is a different body, and it's comprised of people that are not elected as well. So it's a different body.
Sorry about that. Any other questions before moving on? So the next section is 74.1. This is quite a long section. It's the duties and functions of the Commissioner. I'll read a bit of it. It shall be the duty of the function of the Commissioner under the Minister to act as the deputy of the Minister in performing all such duties and functions in relation to the administration of Part 1, prepare budgetary submissions, be responsible for any other administrative arrangements, do such other things as the Ministry may require. Is it, again, I go back to my question, the Commissioner, is this the lead adjudicator, or is this just an administrative role?
Well, that's the problem, is that they share both. So he's doing a commissioner role, and also he's supervising the conduct of the screening officer.
All right, thank you. If no questions, we will move on to section 80. And I've been caught off guard. This is the justification section. For the purposes of this division, the removal from office of a judge is justified only if, for any of the following reasons, the judge's continuation in office would undermine public confidence in the impartiality, integrity, or independence of the judge or of their office to such extent that it would render the judge incapable of executing the functions of judicial office. Infirmity, misconduct, failure in the due execution of judicial office, or D, the judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of judicial office. Do you have any comments on this? Is there anything in here you disagree with?
Yeah, so this is the real meat and potatoes section. So the constitutional justification is in Section 99 of the British North American Act, and that says that judges hold office during good behavior. And then it's expanded into this section. And there's been debate as to whether infirmity is a part of good behavior, and whether it validly should be part of it. But it's sort of being decided that you gotta be able to remove a judge who's getting too old to perform his function, and so that is in there. Sorry, I dropped out. I didn't say anything there. Do you got everyone back here? Okay.
Infirmity. You were
Yeah.
talking about infirmity.
Yeah. So I don't think there's any real sort of conflicts in that area. But where the conflicts are is in misconduct, B, C, and D, in that the Judicial Council doesn't examine the decisions of the judge at all. They're given complete discretion to do whatever they want in a decision, and they view themselves as their entire role is to make a decision, and whatever their decision is valid. And if you disagree with it, your only option is to appeal, even if it involves misconduct. And the screening officer or the judges themselves aren't looking at misconduct at all because they don't want to. So that's the problem. Go ahead, Doug.
Yeah, Pamela, can you bring that section back up again just briefly? Thanks. Yeah, we'll get to this later. I've got some slides I think will be presented out of order on this same section here. But just while we're here, I think it looks to me that this maintenance of public confidence is a critical thing. And it might provide an avenue for public participation if there was a concerted effort to publicize these bits of malfeasance and thereby precipitate action on the part of the council, because it is undermining public confidence in the impartiality. And so that would seem to be a kind of a backdoor mechanism by which there might be some control exercised by the voting public. A comment?
Yeah, that's my concern, is that from the perspective of judges, they view undermining public confidence in the whole system as being something that they can control by eliminating all complaints, and not publicizing anything that shows that. And so they don't debate it, they don't bring it up. It's just destroyed out of the system, and it's eliminated throughout the system. It's eliminated through the BC Courts of Appeal or the Courts of Appeal, and it's eliminated in the judicial conduct. They do not examine it at all because they look at it and go, the screening officer goes, is it a decision? And if it is, then it can't be complained about. And so they're entirely missing the judging of misconduct, and they're entirely missing the judging of impartiality, because they're saying, well, whatever the judge decided, we can't look at it.
So public confidence is maintained by censorship.
Exactly.
Still, if it was public knowledge and there was a public outcry, or even in the press, some discussion of malfeasance, it would undermine public confidence in the process and perhaps put pressure, if it was known that these things are going on.
And that's exactly why I've put my issue before the council and before the public, is because my issue is a judge protecting a lawyer committing fraud, which goes directly to the fair and impartial trial standard of Canada, and the whole equality before the law and everything else, and the rule of law, for instance. And they eliminated it from the system. So it does not, you can't complain about it. And I've also got a complaint about a judge who, anyway, I've got a complaint that just they refuse to answer. So they're not even, and there's no compulsion in the Judges Act if they fail to, I'm not sure if we're going to bring this up, but one of the sections of the Judges Act outlines the rights of the complainant, which are absolutely limited to their right to make a complaint. That's it. Once they've made a complaint, they can't do anything. And the Judges Act now is amended in 2023, removes, as well as removing the right of a judge to appeal to the federal court, has removed the right of the citizen to appeal to the federal court to dispute the decisions of the Judicial Council, which makes the Judicial Council completely irrelevant to the purposes of for the public.
Thank you.
Moving on, I guess, Mr. Rolishka has no questions. Next, we are at section 81. Let me bring this up. Section 81, sub 1. The council shall establish a roster of Superior Court judges who may be designated as members of a panel established under this division. The judges on the roster must not be members of the council. Is this the review board, or is this? I found this section to be a little confusing. Do you know what this is, Mr. Holsworth?
Yeah, I don't really directly know. I think I can't say specifically, but there's a whole series of very, very confusing setups of councils and different appeals that can be made within the Judicial Council, because they're trying to eliminate the appeals to the Federal Court of Appeal. And so they've set up a whole internal system that's supposed to regulate it, but it's all hidden processes, and there's no accountability in the processes whatsoever. So they've taken sort of all the appeals which were going to the Federal Court of Appeal and the Federal Court, which were all open court principle, and they've built them all into now the Judicial Council, which is all secret. So it's just destroyed the integrity of that system.
Go ahead, Mr. Wilishka.
I guess the thrust of many concerns from a lot of people who might be, involved in this process or listening is whether the Judicial Council, in spite of all of these different bodies that they have, that they've referenced and have provided, sort of terms of reference for within their own structure, at what point in time does an average citizen see any kind of possibility of checks and balances over this governing body other than through Parliament, or does Parliament itself even have a mechanism in your mind whereby this judicial review process can be held to account? Is there any link or anything established in writing legislatively or constitutionally that ensures that there is proper parliamentary oversight now that this body has been created?
Right. So my interpretation of the system is that constitutionally, Parliament has the duty. Section 99, they are the judges of judicial conduct, and they can remove a judge, and they're the only body that can remove a judge for grounds of not failing to maintain good behavior. The Canadian Judicial Council and the Judges Act does not change that arrangement. It's just the Judicial Council is just solely an advisory body. And the Minister of Justice still has the actual duty to judge the judicial conduct. He can take the decision of the Judicial Council and he can ignore it if he wants to, or she. They can do, the Minister of Justice has absolute discretion as to whether they want to present it to Parliament to ask Parliament to remove a judge or not. So it's absolutely a smokescreen to judge judicial conduct through another process, which is not in the Constitution at all, and place it within the judges so that they can do whatever they want with it and hide it or whatever. And so it has no accountability to the public and no democratic legitimacy whatsoever. And the reason it was designed was because the Parliament had a corrupt judge back in 1971 called Justice Landreville, and when it went through Parliament, and it was a bit of a disaster. And I think what happened was the judges said, "Hey, we'll look after things for you after this, and we'll do this judicial council, and we'll judge our own conduct, and then that'll be separation of powers, because you won't have the executive judging judicial conduct." But if it completely eliminated the public right to judge judicial conduct through the representatives of Parliament. So they removed that completely, which is a major problem.
Go ahead, Mr. Volushka. Go ahead.
So just to rephrase this, am I correct in reasserting that you have said that Parliament is not even introduced to these issues unless it's first been vetted and approved by the Justice Minister, and Parliament itself has no ability to initiate the process? Is that my understanding?
Well, it's not really defined at all anywhere. In the Constitution, Section 99. It basically says that the Parliament has the duty of it, and it's assumed that the Minister of Justice has the duty because he has the duty to protect the integrity of the legal system, and so he has that duty as well, and to protect the public. But in my case, I served the enforcement procedure of the Charter on the Attorney General, Minister of Justice, and asked him the question to present to Parliament, and they refused to even respond. So you have a disconnect between the public and the Minister of Justice and Parliament, and there's no mechanism to get through that. If the Minister of Justice doesn't want to, then how does Parliament ever hear?
Any other questions?
I'll bring up one other issue on this payment, which is really critical for the public to understand. In 1999, there was a judge who declared the actual law on child pornography to be unconstitutional itself. So he declared not just an exception, but he declared the entire law to be unconstitutional. The Act of Parliament protecting Canada's most vulnerable from being abused. And Parliament, this was brought up in the media and police chiefs across the country. Everyone was completely outraged that a judge could do this. And it was brought into Parliament not by the Minister of Justice, but by just public complaints. And it resulted in debates, and members of Parliament were outraged and absolutely wanted the judge to be removed. But the Minister of Justice pleaded with Parliament and asked the Parliament to allow judges to self-regulate and that they would handle the issue, which they did by taking it all the way to the Supreme Court and dealing with it. But they allowed the judge to remain on the bench, even though Parliament absolutely wanted him removed. And so he wasn't removed. And Parliament allowed a judge to stay on the bench who had declared their law unconstitutional. Major, major problem. And that is the standard of judging judicial conduct to this day is that Parliament will abdicate their responsibility and comply with whatever the Minister of Justice wants them to do, even though a judge declared their actual law unconstitutional and basically said the judicial is supreme over Parliament.
Go ahead, Mr. Bebb.
Yeah, so I take it that when the legal community or the Judges Council took this to the Supreme Court, the law on child pornography was upheld as being constitutional. So really the errant judge in the lower court, whatever it was, either made a mistake or he made some sort of a personal preference choice that was incorrect, at least according to our Supreme Court.
Yeah, sorry, go ahead, Doug.
Well, that could be malfeasance or it could be mistake. I mean, people do make mistakes. I mean, the idea that he would be removed by Parliament, I would go along with that. I think that's a good idea. But they can make a plausible case, I think, that the guy just goofed. Could they not?
Yeah, there's a plausible case that he goofed. But if you can make a mistake of that magnitude, are you a judge? Right? And the Supreme Court did debate the whole constitutionality of the Judges Act and went to the Supreme Court, and it was all resolved except for the fact, can judges declare laws of Parliament to be unconstitutional? And then Parliament basically has no power whatsoever under that regime, is the judges can just unilaterally declare all the laws of Parliament to be unconstitutional. And what is the people going to do?
Any follow-up?
Well,
Go ahead.
That is the big problem. And not just do they declare laws unconstitutional, but they basically redefine and reinterpret language in ways that they can accomplish that. And that I think is a problem that's prevalent throughout the whole system of governance we have, not just in this particular case.
Yeah, and that's the central core issue in my complaint, is that the judge that did that ended up hearing my case in 2007, and he protected a lawyer committing fraud on a court order by calling up the plaintiff and asking her for her recollection of what a judge said 6 months, and preferred that to my evidence, which was the transcript. And the Judicial Council protected him for a period of time, and then he retired. But there's no accountability in the system to the public who is being abused. And then now I'm trying to approach Parliament, and Parliament's already acquiesced to the will of the judges, and they allowed a judge to declare Parliament's law unconstitutional. And so where are the boundaries of judicial discretion? It's absolute, and that's a problem.
Go ahead, Mr. Rolishka.
Yeah, I guess my contribution to that is I've actually had this kind of discussion with parliamentarians, in fact, with a minister of government, and I guess whether or not we leave it in the conversation or not, but that minister of government was the Honorable Lisa Raitt, who was a member of the Conservative government, and that very question came up in a forum debate that we had at one point in time, and the question becomes, if there are potential valid reasons why a judge might rule, maybe even in the particular case of pornography, maybe the legislation itself was not sufficiently strong or clear in order to allow that legislation to pass through to the judicial level unchallenged. At that point in time, the response of Lisa Raitt was, then it's up to us as the government to modify our legislation or change our legislation so that it cannot be debated or disputed or refuted by the courts. Now, whether or not that's the proper response, remains to be seen. But I can tell you for a fact that that was the response from a minister of the state. And what I would like is your comments relative to that, and whether you see that the issue is potentially poorly drafted legislation or potentially overreach by the judiciary, or potentially a combination of the both.
Yeah, you've hit the nail on the head there again, Glenn. You know, it's all about that separation of powers and the checks and balances. And the judiciary has no problem with declaring the conduct of Parliament to be unconstitutional, but Parliament has a very, very difficult. They feel very they're very resistant to declaring the conduct of a judge to be unconstitutional. And the Constitution is the judge's conduct good behavior? And so it requires a judging of judicial discretion. And if you have a judge declaring the law on child pornography to be unconstitutional, merely, sorry, I dropped out there a second, but if you have the conduct of a judge being, that Parliament will not judge judicial conduct. They're failing their constitutional duty to check the conduct of the judiciary. I think that kind of answers your question. Is there something further, Glenn?
No, I think I'm good with that response, other than the fact that, whereas the judiciary seems to hold the legislative branch to a very high standard of conduct, it is, without paraphrasing or putting words in your mouth, I guess, are we potentially dealing with a situation where Parliament, on behalf of the electorate, has not necessarily done as good a job of holding the judiciary to account?
Yeah, and that goes to the core of the problem, is that Parliament is essentially controlled by the executive because, by definition, the executive exists because they have a majority in Parliament. And because they have a majority in Parliament, they control that voice. But the executive also has they have a bias in that they want to have judges on the bench that will protect the executive conduct. So they tend to stack the court with lawyers that are biased to the executive. And that means that they're biased against people. And that's what's happened with the Canadian judiciary, is over time, anyone that has protected the executive has been appointed to be a judge, and Parliament has not performed any role on checking and balancing of the judiciary. So you have basically an alliance of the executive and the judiciary doing whatever they want, and Parliament doing nothing to check the powers of the judiciary. And that's kind of a result of the parliamentary whip system. And instead of independent MPs having a voice, they're all controlled completely. In order to get elected to become a member of Parliament, you have to be a member of one of those parties, and you don't even get a seat on the table unless you submit to the party structure. And the party structure is part of protecting the judiciary because they protect the executive, and it goes round and round in circles in that.
Mr. Walushka?
I guess what we're talking about is a potential failing of the Westminster system of government that requires constitutional change and modification at the highest levels, given that the judiciary has a propensity for supporting not only the executive, but also the existing legislation and constitution that has tests of reasonableness in many instances where somebody, I believe it was Doug Bebb earlier, had on separate correspondence talked about, or maybe it was Bruce Party that talks about correctness rather than reasonableness as being a proper standard. And while this is maybe ancillary to our discussion today, the whole issue of creating legislative initiatives based on reasonableness rather than correctness appears to be a major failing in the system. And are there mechanisms in place other than legislative that are going to correct that? And of course, if we're talking legislative, we're dealing with having to change constitutional precepts and concepts that have been in place for a considerable lengthy period of time. We haven't even been able to get Quebec to sign on to the most recent constitution. So do you see any chance that that's going to happen? Or how do citizens come out of this meeting today seeing that there is any opportunity to make change other than creating awareness and education and demanding more potentially from legislators and the judiciary?
Yeah, that's where we're at, Glenn. And that's why I've presented my problem to Parliament, is to spark that debate and presented it to the public. To spark that debate is because it is a fundamental us versus them situation where you have power exerting absolute authority and discretion over everything that the citizen says, and we have absolutely no rights in the system at all if they want to. And the judges, as well as your idea about correctness and reasonableness and all that kind of stuff, those are all just words that the judges can then interpret to mean whatever they want them to mean. And once again, if you examine the system, is they have the power to weight all evidence and everything and all laws and apply whether they want to balance this or not, or how they want to balance it. And then they claim that it's unreviewable, and that's fundamentally unconstitutional. Is that there is no such thing in a democracy as absolute and unreviewable discretion, and that's what the judges are claiming, is that their discretion can never be examined, and that's fundamentally unconstitutional.
Go ahead, Mr. Bebb.
Yeah, just a clarification. That concept of reasonableness and correctness I did mention, but it doesn't come from me. It came from Jeffrey Rath, I believe, who is well known in Alberta separatist circles by way of a character called Colonel David Redman at a conference in Red Deer. And it relates to administrative law, where on review, the test is this reasonableness, which is kind of defined as whether or not an equivalent bureaucrat would do the same thing. And so it's predicated on a couple of cases. I believe one was Vavilov, and it was mentioned again in the Ostrich case here in BC, where they reviewed this decision on the basis of reasonableness, and is completely divorced from correctness. Is it not? That's not right or wrong, but is it reasonable in the eyes of equivalent administrative operators in the government? So that was recommended to be changed, right? And Rath was saying that it should be possible to change these judge-made laws through statute. So it's correctable outside the amendments to the Constitution. And I don't want to get too far off topic here, but that's where it came from, Glenn.
So anything else? I've actually enjoyed this sort of sidetrack. I think it was very, very good insight into the Judges Act. So thank you to both commissioners and Mr. Holsworth.
So just on that correctness and reasonableness, they're basically saying that if it's a constitutional issue, it has to be a correct decision. If it's an administrative decision, it has to be a reasonable decision. And it's basically just sort of saying that there's different standards of care in the judging of in the judging of things. But ultimately, it's just words that the judges use to kind of describe what their process is, and they control how that process is expanded. But anyhow, great sideline.
So I guess moving on, Mr. Bebb, I came across a question that you had. I'm going to throw this to you. I'll remind you. I'll read it for you, and then I'll remind you of the context. The establishment of laypersons. The council shall establish a roster of laypersons who may be designated as members of a review panel or a full hearing panel established under this division. 3C, meet the other selection criteria established by the council. In case you don't remember, Doug, your question was what constraints might be imposed to guard against stacking the roster of laypersons?
Yeah, this is slightly out of order. There was other ones going back to section 43, I believe, and 60 that I had included in there. So we're jumping ahead a bit here, but I believe that the two sections D and E from section 60 were removed, and power was put into these, and as Trevor had talked about before we had the recording start, this is just kind of an affirmation of things the way they were. But in 2023, it was written into the Judges Act by amendment that, repeal 2023, that and there's another slide I had there that had the previous version of that act, but it was removed kind of from the purview of the council itself and put into these investigatory bodies and so those bodies, it seems to me, and I'm working entirely from memory here, were established to try and correct existing problems. And those problems were, in one instance, the lack of public participation. So they introduced this addition of a third person, a lay person, right? And there's two judges and one lay person, I believe, so that the structure is still judge heavy. And then there's these lay persons who are included on some criteria that's also set by the council, which I could not find. And so it occurred to me that there's an opportunity to stack these they call them these investigators, the panels, with the people that are kind of like vetted and on side with the judge heavy structure already. And so the question would be, what other criteria could be included to try and mitigate or prevent that sort of stacking of these panels from happening in the first place. And I have other questions as well on this topic, but I'll leave that for now with you. Is there a way we can do that? Because, go ahead, Trevor. I don't have my slides here.
Yeah, no, that very, very astute in picking up this part there, Doug. So the whole system has been complained about in that it doesn't have any lay people, it doesn't have any citizens involved, and the council and the Minister of Justice is very aware of this problem, and so they and knowing that my complaint was in the system, they presented this to Parliament and said, look, we're listening, we're listening, we're putting in lay people, and because we're so responsible and connected to what the people want and all this kind of stuff. Then when they actually, I tried to apply as a layperson, and I tried to get information about who was on the layperson panel. Never got a response from the Judicial Council. They're not obligated, so why would they? And but then when an actual layperson was announced, that layperson was a tribunal judge, which, people would not really say that that's that divorced from being a judge themselves. But just to see the hypocrisy of their system is that the layperson was an administrative judge.
Right. Well, jumping ahead again, my question would be if that process was cleaned up and these criteria for selection of the layperson roster was made public, and perhaps additional lay people were appointed so that at least there's a 50-50 balance between the existing judge heavy panel now to have two, kind of disinterested or at least, not biased lay people on the panel. That would appear to be an improvement, would it not?
Absolutely, Doug. And that's exactly, well, I mean, essentially what I submitted as my proposal for judicial reform was that you have a jury of citizens randomly selected from the public to judge judicial conduct. And then the judges could present their argument, and the complainant could present their argument as to why the judge should be removed from office. And the jury of citizens, which is well known as being a bulwark against judicial oppression. That's why we have the jury system in our courts, is to protect from judicial bias, and have that at the top of the decision-making process to catch any judicial corruption going through the system. Because right now you could have corruption going through the system and the entire administration protecting that because they're all judges. And so you will never get judicial corruption exposed because there's no avenue whatsoever possible to get that to hit the public and have a public body actually judge judicial conduct. That's the core issue.
Okay, well, thank you for that. I think we'll get to the slides later. It'll make more sense when I go for this a second time.
Doug,
And move on.
Mr. Bebb, I'm gonna go back to you, and I think this is related to your next question was related to Section 698. So I'll read the portion that you highlighted. Review panel, a person named in the roster of laypersons, and just to remind you, your question was Bill C9 in 2023 added a single layperson to the review panel, still leaving the panel judge-centric.
Right, exactly. And so the question is, where do these lay people come from? What are the unpublished, like I presume, arbitrary criteria by which the council creates this roster of laypersons? And they're probably all just buddies, huh? And then, what can be done to improve that to, increase public participation and oversight? And that was one of the questions that came from that. And I think we kind of touched that a bit. Unless Trevor had more.
Yeah, we've kind of run through that, but it's completely controlled by the council. How they pick someone, and I think in the Judges Act it says something about that they have to be people of diverse backgrounds and stuff of that. DEI basically is infiltrated in there as well, but it's all entirely controlled.
Right. So now it appears to be sort of a partial fix. It's not really a fix. That seeks to address the issue without actually addressing it by having these sort of straw lay people involved in the process.
Yeah, absolutely. And the fact that it was all done, I mean, so you got another problem in here with separation of powers, is that the Judges Act was largely written by the judges themselves. And that's admitted by David Lametti in the Senate. And they just basically said that, yeah, the judges basically wrote this and we're presenting it to Parliament to be approved of. And so you have one body judging and writing the laws and administering the laws. And so you've got complete control in the judiciary of the entire process.
Any follow-up questions, Mr. Bebb?
No, that's good. Thanks. We'll probably get jogged again with our memory with more slides later. Thanks very much.
All right. Moving on. Before we move on, Mr. Holsworth, I notice the sun's coming up where you are. Do you want to take a moment to close a blind or move around? Are you okay? All right, I guess we're good to go. The next section I want to bring up is section 129. Hearings public. I don't even know if that's proper English, but a hearing panel's hearings are to be public, but it may hold all or any part of its hearings in private if it considers doing so to be in the public interest. I think you covered this multiple times throughout this commission, but is this really a good idea to let the judges hold things, do things, conduct things in private?
Yeah, it's completely open-ended sentence, but it's basically trying to say, yeah, we uphold the idea of public hearings, but we also uphold our right to dismiss that anytime we want. And no reasons provided, and just in our entire discretion. So it's pretty open-ended.
I think it appears immediately below it as well. I'm just going to read it, but you don't have to comment again. Prohibition of publication. A hearing panel may prohibit the publication of any information or documents placed before it if it is of the opinion that such a publication is not in the public interest. Now, I understand sometimes you need publication bans, or like sexual assault of a minor, but we're talking about complaints against the judges here. So I can't imagine publication unless it's someone's judge's home address. I think it should be in the public interest. What are your thoughts?
Yeah, I mean it's ultimately who controls what is the public interest, and basically they're saying the judges control what's in the public interest to know, and you have no right to question them. It's pretty much everything.
I was kind of leading the witness there. Does any of the commissioners want to push back on that? Or Mr. Volushka, go ahead.
I think we have a basic premise, and a common theme throughout not only this act, but many acts, where we are prefacing by saying that we have to do things in such a manner as to maintain public trust. And trust of the public, of course, is fundamental to democracy in the first place. However, when you don't have full transparency, you don't have full disclosure on issues, it's very, very difficult for the public to trust that accountability exists either internally or externally in many, many matters. And it seems to me that one of the basic issues that limits the public trust potential in this particular circumstance is the fact that we have no ability to find out, or there's no disclosure concerning the number of complaints that are made to this particular body, the extent of the complaints that are made, whether there are common themes that relate to the judicial process. And my question is, without providing full transparency and full disclosure concerning the input of complaints to this particular body, how is it possible that the Judicial Council and the government can claim that there is any adherence to the necessity for public trust? What are your comments regarding that?
Yeah, it's full smokescreen. It's basically just eliminating complaints from the system completely, and saying that there's no complaints that are illegitimate because we said so, and we have a perfect system, and because we said so. That's the bottom line on that.
Mr. Bebb?
Yeah, I just got to read a quick comment here. Not a comment, but a statement from one of the founding fathers. The liberties of a people never were, nor ever will be, secure when the transactions of their rulers may be concealed from them. Back to StreamYard. That might have been Jefferson, I forget who said that. But absent transparency, there is no freedom. That was a comment to Glenn, really. No question to be put there.
I would say that almost leads into a far bigger discussion, because now you're talking about the emergence of the national security state, where they just invoke national security and anything can be made private. But yeah, and in the concept of justice, it's pretty frightening thought that they can just hide everything and without information, how can we act?
It's there's the defining jurisprudence on this is a case called Roncarelli and Dupleix, and it's about corruption in public officials. And basically, the rule is that there is no discretion. No one in a democracy has the right to make a decision which cannot be reviewed or appealed, and or examined. And so you have judges now claiming, and that's why Louis XIV or Louis XVI was removed from office in France, was for claiming absolute and unreviewable discretion, that his word was the law, and that it was not to be questioned. And if you did so, you would be punished. And that's what we have going on in Canada today, is we have absolute and unreviewable discretion by the judges, and if you complain about it, you will be punished.
So we've actually reached the end of the section by section portion of this commission, and I can open it up for general questions. Mr. Webb, do you have a question?
Yeah, Payman, I think if you look at the most recent version of the PowerPoint slides, below the slide that says old formatting, there's a bunch of questions that I'd like to put to the witness. It's down at the bottom. I think it was redone this morning.
Yes. I made some mistakes with organization. If you could tell me what section it is, I can bring it up and guide me through it.
PowerPoint. Well, it is section 42. And I do have the questions I put here, so I won't be, well, I'll read them once you let me know. I've got two screens up here now. Go back to, I can minimize that. Go back to StreamYard. Yeah, section 42. Okay, I'll bring up my other one here so I can look at it. So what I wrote here was the entirety of part 1 deals with remuneration, which is apparently of great interest to judges. And so we see here in section 42.1 that annuities continue to be paid, even in the rare instance where a judge is removed for cause. And the question arises, should that be the case? And if the possibility of losing benefits, was there on removal, would that serve to reduce corrupt practices?
Yeah, well, yeah, you're right. The Judges Act is probably 50% or larger dealing with judicial compensation. It's mostly about how the judges should be paid and how that should be regulated. But we have a case right now before the Judicial Council, and it's through the federal court prior to the 2013 or 2023 amendments to the Judges Act, which removed the appeal to the federal court. And you've got a judge who's been going through the process for years, full paid, and being suspended for years, and no sign of it ever ending, and being paid $450,000 a year as he's being investigated, and all of his expenses being paid. And that's our system.
Okay, one of the other ones I found here is slide 50. It's actually part 4, division 1, that you've labeled as being S79 onwards. And it's the conduct of the review process, complaints concerning judges. You can bring it up. There's not much in there. These questions, some of these questions would be, suggestions on my part for additions rather than amendments. And what I've said here was the conduct review process lays out a complex sequence of events that might take years to work through. And the question is, would the addition of binding deadlines for completing each stage be of benefit?
Yeah, very good point. Yeah, the whole process hasn't been well thought through, and they in the Judges Act in 2023 they did not think it well through at all either. And there was some constitutional scholars that presented evidence to both the House of Commons and the Senate, absolutely disregarded completely everything they had to say. Richard Devlin is the name of the constitutional author that presented and he's written some great books on the judging of judicial conduct and how it should be regulated. And he made the absolute point to Parliament that this had not been done comprehensively for 50 years, and it should be really looked at in care, and presented arguments and great discussion, completely ignored. And they just was like, the government basically took all the amendments that were made in the Senate anyhow and completely reversed them in the House of Commons and passed the law as they wanted it to be passed.
Right. And I can maybe just keep going, Glenn. I've got a few here up on the screen. And again, with the conduct review process, Division 1, complaints concerning judges, it seems to be that this conduct review process is purely administrative, even in the case where there's prima facie evidence of criminality. And so the question is, should mandatory referral to the RCMP for parallel investigations be required if such prima facie evidence of criminal corruption exists? Otherwise, they can weasel out on an administrative review and avoid criminal sanctions.
And you're entirely correct that it's all administrative, and there's no reporting of crimes or anything like that mandated. There's also a section, I think it's I can't remember what it's, section 10.1 or something like that. It's about if a complaint is made regarding the conduct of a member of the council. So what happens if you're complaining about the conduct of the review process, which is what I did, and they absolutely have refused to respond to a complaint about the conduct of a member of their council. Basically, once again, saying that you cannot complain about the conduct of the review system at all. But it says in the statute that you have to, and that they're supposed to follow a procedure, but they just ignore the procedure, and then you're left with what? Do you appeal to the federal court to another judge and blah, 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 and just the public is left completely hanging in the wind and in a completely abusive process.
Well, I'll continue later, but Glenn had his hand up, so I'd like to let him have a chance here.
Thank you very much, Doug. One of the things that occurred to me is that common boilerplate, certainly in contract law, is that time is of the essence. And it appears that with many of these governmental things, particularly, what we're talking about specifically today with the Judicial Act, is that it seems to be a matter of defer, delay, and other than dealing with issues on a timely basis, the fact that we do not deal with issues on a timely basis is almost the modus operandi. And it occurs to me that if there were some sort of constraints put on some of these functions so that they had to be dealt with in an appropriate length of time, the idea of deflecting or deferring or delaying is actually what is keeping us from achieving results that are going to be satisfactory in maintaining public trust. So
Glenn, you're muted. You accidentally muted.
Oh, am I back again? Apologies. The idea of deferring, delaying, and changing a situation that should be timely into one that goes on forever is probably done for the purposes of assuming that the public is going to lose interest over time, or that something else will happen, on the news cycle that's going to take the place of it. And it seems that governments and judicial bodies take advantage of the fact that they don't have to deliver services and render judgments on a timely basis. Now, I don't know what can be done to deal with that, but it seems like certainly something must be done at some point in time in order to achieve some sort of reasonableness when it comes to the time it takes to get a result.
Yeah, I mean, when you look at all acts of Parliament and regulations and stuff like that, if you look at if it declares a law and then provides no remedy for the breach of that law, then you know that they don't really want it to be enforced, and they provide no structure to enforce it. And then you see other sections of laws where they have the act that's forbidden, and then absolutely they have an enforcement procedure of it and a penalty for failing to do so. But when you see no procedure to enforce it and no procedure to outline penalties, then they're basically saying you can do whatever you want with this, and there's no consequences for breaching it. And that's the system we have.
Go ahead, Mr. Bebb.
Yeah, thanks, Payman. Could you bring up section 80 again, please?
Sure, no problem.
You got it there. Yeah. And so I'd like to point out, or at least bring up, what I consider to be a shortcoming in this list of things that could precipitate action against a judge. And that is number B, misconduct, which is very loosely defined. And I'm wondering if it might be better to enumerate certain, other categories, such as accepting bribes, such as falsifying records, such as engaging in undue influence. And under those conditions, have, maybe you precipitate a mandatory escalation to a full panel hearing, bypassing these screeners if such prima facie evidence of these transitions exist. And it could be criminal as well, precipitating referral to the RCMP for parallel investigation I mentioned earlier. But some of these things are more severe than others, and yet they're all grouped together under this kind of nebulous term, misconduct. What do you think about that?
So, yeah, interesting. In the latest 2023 amendment to the Judges Act, they do provide a mechanism to bypass the screening officer. But the only mechanism is if you allege sexual misconduct by a judge. If you allege extortion or a criminal thing, there's no bypassing the screening officer. It's only if there's sexual misconduct alleged. So you've definitely got a strong bias towards the only judging of judicial misconduct is sexual in nature, and we do not examine corruption at all. That is absolutely the way the system is working, because they are saying that they will not investigate a judge's decision. Now, they also they don't even just judge a decision. That they are judging decisions that the judges make that are not decisions, that are not judicial decisions, because if they are judicial decisions, there's a reason provided and they write it up in their decisions. But if a judge decides that he doesn't want to hear certain evidence, there's no judging of whether that was misbehavior or bad behavior or anything like that. That's completely eliminated by the screening officer, and it never gets further than that point. So it eliminates all those problems.
Go ahead, Mr. Wolitchka.
Yeah, I'm very much bothered by the concept, and you just alluded to it. It seems to me that one of the major points of corruption potential in the judiciary system relates to the admissibility or inadmissibility of evidence. And you can certainly shape the outcome of almost any judicial outcome based on whether or not all the pertinent evidence, the relative and relevant evidence, was even submitted legally to the court. Now, I understand you may have had some of those kinds of issues take place in your own circumstances, but is there any ability through the system to ensure that evidence that was once ruled inadmissible for any reason, whether it was legal, judicial, lawful or not, is there any way to reintroduce that kind of evidence into the system at a superior level to ensure that at least the potential for justice exists?
Not through the Judicial Council. So, like I said before, the Judicial Council is a smokescreen. The actual duty of the Minister of Justice remains unaffected. So it's really just a process to try to say to the public, complain to the Judicial Council. Don't complain to the Minister of Justice, who actually has the duty to present it to Parliament. Don't complain to him. But that's who you should be complaining to, because he actually has the duty to present it to Parliament. Or you present it to Parliament directly, but no member of Parliament wants to hear about it, and they just deflect it, because they just don't want to deal with it. But we need to change that culture, is really what the problem is we've got this culture of don't even look at it, see no evil, hear no evil. It's just not there. Corruption doesn't exist in Canada because we've just eliminated the possibility of it.
Mr. Wolitchka, go ahead.
I think the follow-up to that, and again, I think this is one of the major defects in the system, is that we see far too many instances where judges are telling the juries to disregard evidence, or we have systems where the evidence is not even allowed to be presented to juries. And again, how do we maintain public trust in a system that's supposed to be transparent and accountable, where one individual becomes the gatekeeper for information that may be vital and critical to rendering a correct, appropriate legal decision? And is there any way in which...
Mr. Wolitchka, you're muted again.
Happened again? I apologize. Got to watch those buttons. I certainly apologize to the panel as well as the public. Are there circumstances where a superior court or a Supreme Court or even the Minister of Justice can call for new trials based on evidence that was never provided appropriately at a lower level court? I mean, for us to have confidence in the system, we have to have confidence that miscarriages of justice can somehow be corrected. And it seems to me that if there's no avenue to do that, it would be very, very difficult, if not impossible, to maintain that public trust.
Yeah. So there's an act of Parliament called the Miscarriages of Justice Act, and that creates a formal process. But once again, that is being sort of essentially co-opted by the DEI framework, and it is entirely built around if there's systemic issues that can be called into play, then you can call it. But if there's corruption issues, it doesn't play at all. It's only the DEI framework that works, and that's yeah, so there you go.
Mr. Bebb, go ahead.
Yeah, here's an open question, Mr. Holsworth. Having been through this process, both with the Judicial Council and trying to appeal to the Minister of Justice, Lametti, who's, in my opinion, the worst one that's been there in quite a while, what recommendations would you give us to correct the system or to facilitate complaints? One or two things that you would come to your top of your mind to be corrective measures?
Well, I think the public involvement in the system is the solution. And if the lawyers and judges cannot explain it to the public and satisfy a jury that this is legitimate conduct, then they have failed the test. They can't. If the public doesn't trust them, then they failed, right? And they have to appeal to the public for that trust. And to me, that's the democratic. If you have a failing of democratic legitimacy, you need to restore trust by increasing democratic participation. And we've got this disconnect happening with the legal system and the public right now. And in order to restore trust in it, you need to build back people's involvement in the system. And so that they go, yes, I believe in this system because I can see how it works and I can understand that I participate in it, and I can see that it's open. And I can see that it processes these complaints legitimately. But the current system is closed doors and just obstructionist and does nothing to, except for deleting complaints from the system, does nothing to enhance our system at all for being accountable. And
Just a follow-up question. Would it be possible, in your opinion, to restore the ability of the complainant to appeal to the court system itself? You mentioned it was removed both for the judges and for the counsel and for the complainant or yourself, to be able to take up a rejection or a screening of your complaint through the normal court system on appeal. Would that be something that we could do in the Judges Act, just to restore that single point of entry?
It does to some extent, but you still have the problem of judges judging judicial conduct, and it's a breach of natural law that no one can be a judge in their own cause, and they're judging their institution, and of course they're biased towards protecting members of that institution, and they're going to circle the wagons all the time, and protect themselves by protecting other judges. And it's like a union or something where you cannot allege misconduct by internal actors, and that's what we have going on. And it seems like we've almost got that going on in Parliament as well right now, unfortunately, with sort of foreign interference, and we can't complain about foreign interference, and no, they won't check themselves, and you've got this sort of complete lack of integrity within the system itself, and where do you go from there? And you have to go back to first principles and go and restore democratic principles and integrity principles right from the word go.
So it would be some sort of layperson review body or some other mechanism like that?
Yeah, that's kind of basically what I proposed. Is it, you have the citizen jury in charge of monitoring complaints at the Law Society level, at the police conduct level, at the judicial level, at the parliamentary ethics and commissioner kind of level, and then they have authority to direct it to the RCMP to actually conduct the hearings and decide whether or not they want that they just have complete control over it, and that will restore public's confidence in the system because the public is involved and we have a jury, and I think that, to me, that's the solution.
When it comes to public, review, I'm starting to wonder if this isn't in part, a failure of the press to do proper reporting on these sorts of things that go on.
Certainly the lack of freedom of the press is a because the press is a body that's responsible for checking the judiciary. But once again, if the media is captured by the executive or by DEI systems, then you're not getting the checks and balances on the judiciary performed by the media, and then you're left with the public. And it's like, well, if the public has no access to further complaints, it's just rumblings by the public. Then you're setting yourself up for what the preamble of the UN Human Rights Commission says, that the public has a right to revolution if their rights are not respected. And so there's definitely a democratic need for public involvement at the highest level.
Thanks very much. That's all the rambling questions I have today.
I actually don't have any more questions. All my questions were on the front end of the episode, Commission. Mr. Wolushka, do you have any other comments or questions?
I think we've probably dealt with a lot of the minutia details within the act, and luckily we've been able to augment that with some of the fundamental problems with the larger nature of ensuring that we have proper accountability and the ability to generate public trust in how we're governed and how we're judged. And unfortunately, you brought up the issue of the fourth estate being a necessary component in that process. And I guess one of my comments is that, if the fourth estate mainstream media has abrogated its responsibilities and instead become a tool for government and bureaucracy to maintain status quo rather than questioning, the veracity and the compliance, I guess, of status quo to what's in the public best interest. It's incumbent on things like the People's Parliament and incumbent on people, who have been involved in the system, like our guest, our expert today, Trevor Holsworth, to make sure that we get that information out to a public that is somewhat apathetic, but also somewhat misinformed because the information is not being made readily available. And I think that we have a responsibility, even as citizens, who are not part of the process, who are not vetted and engaged and don't have um, an interest other than proper rule of law and proper ethical and moral, judgment towards issues such as this, to make sure that we do stay involved, get involved, and encourage others to get involved with that kind of process. And I commend you for what you're doing, Mr. Ascari, and also, people that are volunteering as commissioners and also as informed, witnesses or experts who are bringing forward issues that are necessary and vital to the public process. And without people like the fourth estate getting involved and doing their job, then we're just going to have to do it for them. So again, I commend everybody that's involved in the process. Thank you for stepping up and doing what you're doing. But I think that we as citizens have a responsibility to do more in order to make sure that we receive the government to which we are entitled. And I guess that's a bit of a long-winded way of saying that, we actually have to do an awful lot more of this to ensure that we do receive the government that we deserve.
Thank you, Mr. Walushka. I'll take that as your closing statements or wonderful statements. Mr. Bebb, I'll go to you, and then if you want to make whatever you'd like to add and any closing statements you may have.
Yeah, nothing to add other than to thank Trevor Holsworth. I don't think we could have come across, a more informed character, not just on the letter of the law, but on its practical application or lack thereof, having been through the process for, I guess, decades now. So thanks very much for appearing here and to help us bring these sorts of travesties to the public's attention. Thank you.
Thank you, Mr. Bebb. Mr. Holsworth, I'll go to you. If you have any closing statements, go ahead, please make them now.
Yeah, thanks. Thanks to everyone for having this forum, and I applaud you for your diligence in having this debate and bringing this into the public's attention. I definitely attempted to do so during the debate on the Judges Act as it went through Parliament. But to close off on it, it comes back to what democracy means, and it's the consent of the governed, and to be informed about the processes that you're governed by. And the oldest law in existence is the Code of Hammurabi, which was the purpose that he outlined was to make justice visible in the land, to destroy the wicked person and the evildoer, that the strong might not injure the weak. And that's the purpose of a justice system, is to protect the public, and that's what we're failing to do in our current system, is have any accountability and any protection of the public.
Thank you very much, Mr. Holsworth. I'd just like to say that the purpose of these commissions that we've set up, the People's Parliament, is to empower the people and let them understand that they can make change on their own. We don't have to wait for government to enact these changes. They can come from the bottom up. To that end, anybody watching, if you would like to get involved, either as a subject matter expert or as a commissioner or as a moderator, please reach out to us at peoples.parliament.ca@gmail.com. We could use any support we can get. I'd like to thank very much my two fellow commissioners, Mr. Doug Bebb, Mr. Glenn Balushka. Thank you very much for adding structure to this commission. Mr. Trevor Holsworth, thank you very much for volunteering your time to be here. And on behalf of all Canadians, we appreciate the sacrifices you've made over the last few years, decades, and going through what you went through so that you can come here and educate us and the rest of Canadians. Thank you very much. Big thank you to the audience as well. One final statement. If I could ask the three of you to stay with us until after the commission, that would be appreciated. Goodbye, everyone.